Welcome everybody to this week's edition to Reverse Mortgage Weekly, where we try to provide information that's helpful for people who are looking for reverse mortgages, and also provide contacts that will be helpful for people in the field. We have a very special guest today. We have Mr. Mark Masters of Glatstein and O'Brien with us today to talk about some estate planning. Welcome, Mark.
Hey, thank you. Thanks for having me. And hello out there in video land.
Absolutely. So, yeah, I had met you at at a networking event, and I just, I know that we had kind of connected, and I really look forward to having you on today because this is subject matter that I think is vitally important and can really save people a lot of time, energy, working with a professional. So I really appreciate you coming on today, and I'm looking forward to learning a little bit more about estate planning here.
It is my pleasure. It is my pleasure. This is what I do. So obviously I don't get out much. Anyway, go ahead.
Well, so I wanted to cover some of the things that people might run into as far as major estate planning mistakes. So, can you tell me a little bit about dying in estate?
Oh, intestate. And that basically means without a will. And so if I die intestate, I'm really turning over all the decision making to somebody else, because the state of Colorado, in its wisdom, has written everybody a will. It may not be the will you want. It may not do the things you want it to do, but by God, the legislature has written you a will. But where that falls down is that, okay, it's going to, the intestate statutes are going to say how my assets are going to be divided, for example. But if I have minor children, or if I have people who, okay, they may not be minors, but it might not be a good idea to put a bunch of money in the lap of an 18-year-old, or even a 21-year-old. There's no provision for those minor children. So sure, if I die and have two children and no spouse, then yes, my kids are going to get everything in equal shares, and that may be more or less what I would have wanted. But if they are minors, there's going to, we need a protective arrangement because they are minors.
Yeah.
Minors can't hold assets under our legal system. And so then we're going to have to set up conservatorships for each of those children to receive their 50%. And that's about a $6-7 grand job for an uncontested conservatorship. And again, who's going to be guardians for minors? Who's going to administer my estate? There is a hierarchy in the statute. Once again, it may not be what I want, but there is a plan out there. Now, obviously the thing to do is to step up to the plate and issue my own set of instructions.
Yeah.
And this is where I can appoint the people I want to do the various jobs for me. Who's going to administer my estate? Who's going to maybe be trustee of trusts, guardians for minors, if I have minor children. This is the way I make the gifts I want to the people I want in the manner most appropriate for them. And this is the way I am going to take probably the biggest bite out of taxes if I have a taxable estate. And so, all of those reasons are why you probably, do not, and particularly if, for example, I have a sibling or a child whom I don't want to receive assets. Again, it's my prerogative, but time to put my big boy pants on here and get this job done, get it in writing, in a proper will or a trust, so that if I don't want my no good Nick brother to receive anything, that's how we give that effect.
That's extremely important, and someone really sat me down and had, the come to Jesus talk, like, you need to get a will done. And they really resonated with me because it really is the responsible thing to do. And I've seen so many situations where someone will pass or something like that, and the kids are squabbling and there's no will, and it becomes a very difficult situation. So, wow, thanks for elaborating
Yeah,
on that.
my pleasure.
So what about like appointing like co-fiduciaries in an estate planning documents, or appointing fiduciaries who are ill-suited to do the job? I mean, is that ever something that comes up?
Oh, oh yeah, all the time. So first thing, um, any kind of co-fiduciaries, personal co-representatives to administer an estate, co-trustees, agents under powers of attorney. This is one of these things that may sound great, you know, oh, well, I love all my children. I want them all to, participate. But as a practical matter, it is a train wreck waiting to happen. It's a train wreck waiting to happen because that does mean they do all have to agree. And particularly if my kids didn't exactly get along while I was alive, um, when they were hopefully on their somewhat better behavior, I'm here to tell you that after that senior generation dies, that's when the gloves come off.
Yeah.
And and because really creating co-fiduciaries, again, it's one of these things that sounds great in theory, but anyway, that's when the gloves come off. And because really what you're doing is you're giving everybody a veto on everybody else.
Yeah.
And oftentimes what happens then is we then get to an impasse, a standoff where, I don't trust you, you don't trust me. And so therefore I'm gonna pretty much veto everything you want to do, and you're gonna veto everything I'm gonna want to do.
Yeah.
And after both of us have spent $50,000 or $100,000 in legal fees, and I am not joking about that.
Yeah.
But after we have spent, big bucks on legal fees, and we eventually end up in court, because that's where we're going ultimately on this.
Yeah.
The judge is going to fire both of us, and is going to bring in a third party, and it becomes one of these cases where the only people that win at the end of the day are the lawyers.
Yeah.
Because they're the ones who are going to get paid out of the decedent's estate, mind you.
Yeah.
They're the ones who are going to get paid, and so we've now spent, $75,000, $100,000, $150,000 on your lawyer and my lawyer,
Yeah.
which is 75 or 100,000 or whatever less that you and I are going to get now.
Mm-hmm.
Even though, brother, I hate your guts because of this. And so, again, the only people that win at the end of the day. So what's the solution? And the answer is, Harry Truman said it best. The buck needs to stop at one person's desk at a time.
Yeah.
We need to have consecutive, and I talk to clients about a depth chart. Who's the starting quarterback? Who's the backup? Who's the third string? But one person at a time. And if this is going to be controversial, then maybe that's the time where we should bring in an impartial third party to administer this estate. We should bring in an impartial third party to administer this trust. It could be a bank. It could be a, if there is a Uncle Bob, family member who is willing to, who thinks he can keep everybody more or less satisfied because he is an impartial, or she is an impartial third party, but maybe that's the solution is perhaps to bring in a third party. And then the other is we need the right people for the various jobs. This is not one of these things where it's a birth order affair, or where it is a this is a job for my son. Yeah, okay, so this is the guy who's living in his jammies in your basement playing video games all day long. No, I think I want your daughter with the MBA. Thank you very much. So again, we need the right people for the job who, who know what they know what they don't know. They know to reach out for professional advice, to a CPA if there's going to be income tax returns that need to be filed. Zach, to somebody like yourself, if there isn't enough income, and yet we have we have a house, because sometimes a reverse mortgage can, really work wonders in terms of keeping that person not only in their house, but making sure that in their retirement, they have their needs met. But whatever it is, they know what they know what they don't know. They're a good administrator. They can delegate. They can ask good questions. They don't have to do necessarily everything themselves. They can hire things done, but that's who I want to administer my estate. That's who I want to administer a trust. And again, one person at a time, consecutive is better than concurrent, because this is not the fifth grade play where every kid needs to get a speaking part. Oh, well, I have 3 children. I need to give them all a job. No, you don't. No, you don't. We're looking for the best people for the job. And yes, that may be your adult, that may be 1 or 2 of your adult children. It may be a third party. But again, we're looking for the best people for the job. And again, that may be none of your kids. We do need to bring in a third party because there are, lovely people, honest folks, nice people. This is just, but facts and figures and is just not where their head is. They're creative people, for example. Well, that's fine. Great. They're just not suited for this. Fine. Let's bring in somebody who is suited for this. It's just, that is just so far superior.
That's wonderful advice. I mean, you painted the picture really, really vividly about if you don't plan things up front, things can go really wrong and get really costly for folks. So,
oh, well, it's great for lawyers, it's great for lawyers, but really I'm trying to keep people away from litigators. Yes, I am a lawyer. No, I don't go to court. I'm trying to keep people away from litigators.
Sure. That's great advice. So how about living interstate, not having a comprehensive and up-to-date powers of attorney? How does that affect people's situation?
Oh, well, that's the whole other part of estate planning. In fact, friends, this is, over the span of a lifetime, we are statistically more likely to become incapacitated than we are to die. And a will or a trust, well, actually doesn't do me much good. This is mostly going to be activated after I die. But the point I'm making is that the thing that's most likely to happen to you ain't that you're going to die. The thing over the span of a lifetime, the thing that's most likely to happen to me is that I'm going to become incapacitated. And despite the urban myth or whatever it is, just because I'm married or just because I may have an adult child, they cannot automatically speak and act on my behalf. Okay. And so we need powers of attorney, and typically that's going to be a financial power of attorney and a separate medical power of attorney, where I can delegate someone. And yes, it could be a spouse. It can be an adult child. But whoever I want to, again, speak and act on my behalf, because as I said, that's the thing that's most likely to happen to me is I'm going to become incapacitated. And I need someone to be able to, and alternates. Remember, I talked about A, then B, then C. That person plus maybe an alternate or two who can do the job. Because people think, well, I've talked with my son, my daughter, and yes, they'll be my agent. Okay, great. What if they're in a car wreck? What if they can't do the thing that they promised that they would do for you? Well, that's why we need the alternates. Anyway, but people need the powers of attorney, as bad as, if not worse than a will, as bad as, if not worse than a trust. And so that's the whole other side of estate planning is planning for disability. Now, that also means that maybe I need to look into long-term care insurance. You know, maybe I indeed need to look into that reverse mortgage to make sure that I am going to, or if someone is trying to help me, such as be an agent under power of attorney, that there is adequate cash to pay for my needs. Because it doesn't get cheaper after you retire; it can get more expensive, particularly in the last few years of life. And so once again. That planning for disability is not just, sure, I've got the documents and that's great. That's a good start, but, make sure you don't overlook the financial side of it as well. And again, if, checking whatever public benefits might be available, pensions, 401ks, IRAs, yes, maybe a reverse mortgage if that's appropriate. Et cetera, et cetera. But that's the whole other side of the equation. Because, friends, the alternative is, if I don't have those things, and I have the stroke, and I have the fall, or whatever it is, then again, I mentioned conservatorships and guardianships before, and again, that's a $6,000-7,000 job for an uncontested guardianship conservatorship. Once again, really good for lawyers, but boy, wouldn't it be better to spend a few $100 on those powers of attorney and choose who I want to speak and act on my behalf versus that conservator or the guardian. It's just as the CPAs say, pay me a little now, pay me a lot later.
Yeah. And a good CPA is worth its weight in gold. I mean,
well, but it's just, it's a case of pay a little now and take care of the problem, or wait till the problem gets really big and it's going to be a lot more expensive to solve down the road.
Right. It's kind of like that old saying, being penny wise and pound foolish.
You betcha.
And
I can't endorse that enough. Don't be penny wise and pound foolish.
Absolutely. And do people use that approach sometimes when they create like an intergenerational joint tenancies or something like that?
Or people shoot themselves in the foot all the time. So they're down at the bank, right? And we have elderly Mrs. Jones, right? She's down at the bank, and that earnest young man, that earnest young woman she's talking to, oh, Mrs. Jones, don't you want to avoid probate? Don't you want to put your kids on your bank account so that way when you die they can get your money, And the Mrs. Joneses of the world think, well, no, that sounds like a good idea. Okay, well, yeah, sure, let's do that. You got to understand, and this is my perspective after 30 plus years of doing this. That the financial industry in general, and sorry, financial planners and bankers and so forth who might be watching this, but they kind of push older people to, yes, create these, put your kids on the account. That's by the way the words they use practically every time. They kind of push older folks to do this. They think they're doing them a great big favor. And really, they're not, for a number of reasons. For example, okay, let's say that I indeed took the advice of that earnest young man or woman at the bank and hung beneficiary designations or created joint tenancies. Same thing, same result, I guess I should say, for my kids. And then I die, and so I've got maybe a house, and I don't know, some other assets, contents of the house, a car maybe, but that's about it. Not exactly a Rockefeller here. Well, okay, fine, sure, joint tenancy. That money indeed goes to those adult children right away. But who is the poor schmo who's administering my estate? All of a sudden, that person has no liquidity. They got no cash in the estate with which to pay my bills after I die, because they're legally obligated to pay those bills. I've got income taxes for the year of my death that need to be paid. Other, funeral and burial expenses.
Yeah.
It can add up. And so we have the Porschmo who's administering my estate, who has little or no cash to do it with. And now they're forced to make decisions that nobody wanted. For example, maybe the whole plan here was to hang on to the house, hang on to mom's house, fix it up a little, and turn it into a rental to provide income for us adult children. Well, if I'm the personal representative and if I'm the administrator of that estate, and I've got all these bills to be paid from the, by reason of the decedent's death, but I got no cash to do it with, then sorry, that house may have to go on the block, or I'm going to have to borrow against it, or, it's getting even weirder, or I have to go to the very same people, and I've had this happen, the very same people who got all those liquid assets, the stocks, the cash, and so forth, and get loans and pay interest.
Yeah.
And how freaking weird is that?
Yeah.
Okay.
Yeah.
Whereas, here's where I'm going with all of this. Whereas, if I had simply died with those assets in my estate, had not created those intergenerational joint tenancies, thinking I was really helping everybody out when I'm really not, then my personal representative now usually has sufficient liquidity to do their job, because part of what I am probably trying to accomplish is to make it easy on my kids, on my grandchildren, or whoever after I go. Well, you really weren't sure. They got the cash, but my personal representative, as I said, doesn't have liquidity to do their job, and may have to make decisions that nobody wanted at all. But anyway, whereas if I had simply died with those accounts in my estate, no joint tenancies with my kids or anything like that, my personal representative now has money to do their job. It's simple to make sure those bills are paid. Remember, people, assets are not frozen at death in Colorado. It used to be that way years ago, and is still that way in some states. But when Colorado abolished its state inheritance tax, which it did in 1979, it abolished the practice of freezing assets at death. And so, in the type of estate that I'm describing, where there's lots of liquidity, if we want to make one or more interim distributions along the way, we can, because assets are not frozen at death, right? We can keep, enough cash in the till to do what we got to do. But if there's excess, fine, we can make one or more interim distributions along the way.
Yeah.
So you're thinking to yourselves, and then I'll be quiet. You're thinking to yourselves, well, yeah, but my kids got the money, right? And they can use it for these things. Well, yes, they can. But here's the thing there. Many expenses of estate administration are deductible for income tax purposes, not all, but many, when they're paid by the estate. When they're paid by an individual, they're not.
Oh, okay.
And so, so I've had the situation more than once where, all the accounts, joint tenancy go to adult daughter, adult son, whatever. And morally, they say to themselves, well, this is mom's money. This is not mom's money. Ethically, this is not mom's money, or this is mom's money. This is not my money. This is mom's money. But legally, it's not. Legally, it's yours now. And so when I reach into my pocket and put money on the table to pay those bills, to pay those income taxes, funeral and burial expenses, or whatever, cremation, whatever, it's money coming from a third party, not from the estate. And any prayer of deductibility goes right out the window.
Oh, wow. Wow.
you know, and so that adult child says, well, it all came to me. That isn't right. I need to share it with my siblings because that's the right thing to do.
Mhm.
And yes, morally, ethically, it probably is. Okay. Well, here's the kicker there. Here's the kicker there. When that, the child who got all the accounts, all the stocks, all the bank accounts, all of
Mhm.
that, you know, then starts writing checks to the siblings,
Yeah. Mhm.
those are probably taxable gifts.
Oh, wow. Wow.
So here again, using these intergenerational joint tendencies, is one of these things. It sounds great. It sounds like you're helping, and you're really not. You're really not, because
Wow.
because again, assets are not frozen to death in Colorado.
Yeah.
Because that was the real reason years
Mhm.
ago, back when people, back when assets were frozen to death, was so that yeah, we could make sure that cash was available to buy groceries, for
Yeah.
example,
Yeah.
for the surviving spouse or the children, or when think of widows and orphans and everything, but cash was available to buy groceries and
Yeah.
and things like that, and but it's one of these old practices that has endured, even though really there's not necessarily a good reason for it anymore.
This is such great information, Mark. I mean, because I had no idea. And you,
I could talk for hours. Anyway,
no, this is great stuff because, just someone who knows nothing about this, hearing that, some of the practices that I think a lot of the normal, average, everyday Joe is going to say, oh, yeah, put your name on the account. Sounds like a great idea. But hearing the explanation why it's not is really, this is enlightening. This is really good stuff. So tell us a little bit about botch beneficiary designations,
well,
naming
sure.
children or having out-of-date designations or the
Yeah.
wrong beneficiary.
Oh yeah, see this all the time. So people, they get a job, they go down to HR, they designate beneficiaries for that 401k or life insurance or whatever it is, you know, and then they forget about it. And then they forget about it, or, oh well, welcome aboard and congratulations, you're working here. And you've got this 401k, and they go, well, and so they put down, for example, their minor children, you
Mhm.
know, or they have out of date beneficiary designations. They have named an ex-spouse. See
Oh,
that?
wow.
Yeah, think about it. They have named an ex-spouse,
Yeah.
you know, and really a lot of wealth these days, some would argue perhaps most wealth these days, is not necessarily distributed under a will or a trust.
Hmm.
It's by these beneficiary designations.
Yeah.
And so, the whole minor children thing, the reason that's a bad idea is because, remember, minors can't hold assets under our legal system. And so we're going to have to set up a conservatorship for that, for each of those minor children. And,
Mhm.
and I told you how expensive that is.
Yeah.
And there's going to be annual reports to the court, and my conservator is going, so let's say, kids going to college, something like that, wants to make a withdrawal. We want to buy a car for this kid. Well, we got to go get court approval for that.
Yeah. Mhm.
Just a whole lot of rigmarole, expensive rigmarole, I might add.
Mhm.
All right. And so because really what I should be doing is having my estate be the beneficiary, so that
Mhm.
if I check out, that life insurance money, for example, will go to a trust for my kids' benefit,
Mhm.
but not to my kids directly. See, that's the difference. I want it to go into a trust for their benefit that might exist in my will,
Mhm.
for the benefit of my children, of my grandchildren,
Mhm.
rather than to them directly.
Yeah.
Because
Yeah.
sure, I have more than once in my career, where grandpa leaves 50 grand to little Billy,
Hmm.
in a life insurance policy or something like that, and little Billy is 12, sure, little Billy can get the money, but we're going to have to set up a conservatorship, and and so I get to charge, little Billy and be paid, and so and so let's say it cost me 5 or 6 grand to do that, and as I said, that's probably about right.
Hmm.
10% of the money that Grandpa wanted to go to little Billy now went to a lawyer.
Yeah. Yeah.
So in a way, I'm kind of trying to talk myself out of more fees here. Um, and then the whole thing about the out of date beneficiary designations.
Yeah.
It could be that if I were to die, that ex-spouse is the last person on the planet that I would want
Mhm.
to get my 401k, to get
Yeah.
my life insurance.
Oh,
Um, so we get the wrong beneficiaries, or I named my brother, thinking that, oh well, the money will go to him and then he'll give it to my kids. Yeah, but my brother died 2 years ago from cancer. My brother died, or whatever, or my brother is now having financial problems of his own, and I'm not entirely sure that if I died, he would in fact live up to his promise that he made to me, 18 years ago, 13 years ago, whatever it was, a long time ago.
yeah.
Now that he has financial problems, or sure, it went to my brother, but he was in a car wreck
Hmm.
and got sued.
Yeah. Wow.
And so my life insurance money, my 401k money,
Mm.
is now his legally, and therefore potentially subject to his creditors.
Oh, wow. That's amazing. Wow. This is such great information, Mark. This has been really, really good having you on today. Once again, this is Mark Masters at he's counsel at Glatstein and O'Brien. And his office number, if you want to reach him, 303-436-9121. This has been great, Mark. I mean, I'm very like this is it's very eye-opening. It's such valuable information for people. So thank you so much for coming
You're
on
welcome.
today. Did you have anything in closing that you wanted to share with our audience?
Just the whole business about, don't be penny wise and pound foolish.
Mm-hmm.
You may have worked a lifetime, or worked very hard to get where you are, you know, and this is not necessarily the time for LegalZoom,
Yeah.
because just because it says will, just because it says power of attorney up at the top, doesn't necessarily mean that it is truly appropriate for me now,
Yeah.
or forever. These things, my life changes, my
Sure.
documents need to be updated from time to time. So just, yeah, again, just please don't be penny wise and pound foolish. Yes, it's no fun to to perhaps to write that, come in and talk to somebody like me about estate planning, and the have to write a check, but just the alternatives, are just so much worse, and
Yeah.
you're really not necessarily doing your family any favors by trying to be penny wise and pound foolish, or by procrastinating.
Absolutely. That's such great advice. Well, thank you so much again, Mark, for coming on, and I hope to have you on again sometime.
I'd like that. I'd
Great.
like that. I
Well, I
beg
hope you
your
have
ears
a
some more.
absolutely. We'll check in with everybody later, and if you have any questions, we'll have Mark's contact information on